सिर्फ एक हुक्मनामा है 6/A वाला जो प्रॉपर्टी है उसमें सिर्फ 4 बाउंड्री है, बाकी सब में है। सो नेक्स्ट सर दिखाते हैं। शेड्यूल ए का पहला प्रॉपर्टी है प्लेट पेज 14 Jammu did Magar finding. P.S. Tamar, DT Karachi, land measuring 1.6 acre, 67 acres, plot number 688 of Khata number such and such, bounded by north, south, east, west. Second, third, fourth, fifth, sixth, 7, 8, 9, 10 जो कि 12/2/60 से जो है 6/A वाला से उसमें सिर्फ 2 ही बाउंड्री, उसमें से बहुत सारे तो ये क्लेम भी नहीं कर रहे। उसमें से 2 ये क्लेम नहीं करते हैं, 3 भी नहीं करते हैं, 4 भी नहीं करते हैं, 6 भी नहीं करते हैं, 9 भी नहीं करते हैं, 7, 10, 8 करते हैं और 5 करते हैं। और बाकी जो प्रॉपर्टी है
एक बजे एफिलिएट कोड का जजमेंट
जी इसका और 2 लाइन दिखा देते हैं। बाकी जो प्रॉपर्टी जो आपका इसमें 11-12 में है, 12 में भी 4 बाउंड्री है, 13 में 4 बाउंड्री, 14 में भी 4। सिर्फ 2 to 10 में 2 बाउंड्री है, जिसमें से हमने कहा अभी 2, 3, 4, 6, 9 और 10 ये क्लेम नहीं कर
दिखाई दे रहा ऑर्डर 7
ऑर्डर 7 हाँ पता ऑर्डर 7 रूल 3 देखा जाए where subject matter of the suit is immovable, where it order 7 rule 3 where the subject matter of suit is immovable property. The plan shall contain a description of property sufficient to identify it, and in case such property can be identified by boundaries or numbers, Boundary is not essential. In records of settlement or survey, the applicant shall specify such boundary or numbers. So far as the numbers are concerned, it is already there. And boundary is also there, but in some of the properties, only two boundaries.
So those boundaries could have been substantiated through oral evidences, which has not been discussed by the appellate.
Though the trial court has discussed whether those findings are correct, those findings are perverse, or such findings is at all not possible. These are the findings which have to be considered.
Okay, let us see the finding of the learned appellate court.
Yes.
With respect to 5, 6 and 7, they have taken it up together.
Yes.
Para number 12.
Para number 4, your worship, are the issues which is
That I'm
issues framed by the trial court. No point of determination was also framed by the appellate.
No, the appellate court has taken up the same issues and has dealt with issue number 5, 6 and 7 in
But
para.
what I am saying that there is no independent point of it.
That's right. Issue number 5, 6 and 7 has been taken up by the appellate court in para number 12.
Serial 9, your worship, so far as 7 is concerned, it is discussion with respect to what are the documents. Before that, para 5 has, my lord will find the oral persons who have deposed.
I want to see para 12.
Yes. May I read from para 9?
Para 12.
Para. The counsel for the appellant have relied upon ruling in 1968 BSR Patna. Both parties have filed unregistered hukum. The suit land is a Kutkati Jamidari. The father of Ram Sevak Mahato, namely Feku Mahato, was Diwan. This finding is coming by the trial court. They had said, though they are in the written statement, my lord will find that there is a pleading, but there is no evidence. This is just a pleading. In the defendant number 2 and 3, the written statement filed by 2 and 3, my lord will find that they have stated that his father was a manager, not only the one, he was a manager. That what is the pleading. But I have examined the evidence of Sampati Devi. She has not deposed. So it is part pleading.
And it is not an admitted fact.
Hmm?
This is not an admitted fact.
Not, how can, if suppose somebody is pleading something like that,
That's
even you could have neither any document is on record that my father was a divan, nor there is an oral even supported by the evidence. Now, my lord, meaning the plaintiff were related to that. This is also a finding, my lord, which is the father's one. Para 2 of Khatiyan describes that without prior permission of the landlord, no rayat can reclaim land. The Honorable Court has given verdict that acquisitions of rayati interest given by the oral settlement accompanied with the delivery of possession and acknowledgement of tenancy by acceptance of rent. The case may be decided on the hukum. Plaintiff have claimed the entire land in suit A of the plaint. There are 14 items of the plaint. 1, 2, 3, 4, 5, 6, 8, 9 and 10 were settled to Feku Mahato by Kutkati Zamindar. Item 11, 12 will settled with Ram Sevak Mahato by Kutkati Zamindar. Item 13 was settled to Govind Mahato. Item 14 has not been discussed in the plaint. There is some confusion regarding Exhibit 6. The Net Court below has considered Exhibit 6 beyond description of plaint. There is some different distance regarding the Exhibit 6 and 6 by B also. These exhibits do not match with the items mentioned in the schedule of the plaint. Only 2 boundaries have been given in the Punam. But the learned advocate for the respondent submitted that only 2 boundaries have been mentioned because of the Khatiyan case. 2 boundaries. That is with respect to the property. This was item number 2 to 10. 2 to 10, out of which many they are not there. But so far as the other hukumnama, the, all the boundaries are already there. So, my lord, here also a general and a sweeping, my lord, observations has been made. Learned and neither the learned appellate court, my lord, nor the trial court took pain to my lord, see whether the boundaries are there or not. Merely out of 2 to 10, such statements or such findings has come out. The dispute between the parties is regarding entire matter, but the plaintiff has stated that the proceeding of 145 CRPC against the mentioned in Schedule B of my lord, what has happened? That earlier, my lord, the 145 proceedings, your lordship, were initiated with respect to Schedule B, which is the part of the my lord, schedule. But my lord, the litigation, the parties are litigating over these land schedule, and my lord, it had come up before this court. Thereafter, my lord, there was an observation. The position was declared in our favor. Then, my lord, they have come before this court. My lord, this court said, my lord, that there is no apprehension of breach and peace since long the parties have not breached the peace. If the occasion will arise, such proceedings will be filed. Thereafter, these proceedings, CRPC proceedings under 145 CRPC was filed. That those documents we have brought on record, that is the Exhibit 1. In that case, the learned magistrate, your lordship, learned subdivision officer was duty bound to declare who is in possession, because it's an admitted position that these titles are not decided in the such proceeding. But he failed in this duty, and he said, no, it is a matter pertains to title. Thereafter, this title suit was filed with a prayer that our title may be declared and the possession may be confirmed. So that part, your lordship, is also he has not properly took pain to what is the actual dispute between the parties, and just sweeping observations has been made, and coming to that, the finding is like that. Merely because the proceeding was dropped, and what was the reason to be dropped, that is to be taken into consideration. Even before the High Court, the position was declared in our favor. They went to High Court. High Court said,
Mr. Sani, just respond. In order to sustain the appellate court's finding, you are looking at the trial court's finding.
I am looking at the
Findings recorded by the learned trial.
yes.
Otherwise, in the appellate court's judgment, there is no discussion.
There is.
And
I
there
just
is-
showed you also.
There is no discussion, there is
There
no
are 13
sufficient
years
discussion.
kindly permit me to close.
And you see, Order 7, Rule 3, it talks about the pleadings in the plaint. Correct?
Yes.
Pleadings in the plaint is not defective.
Number
Important is whether that boundary, whatever has been stated in the
Order
plaint.
7 Rule 3 is very correct, madam. It is rightly placed.
Yes.
I will also say that the Order 7 Rule 3, what is the requirement?
Yes.
Now, apart from this, if the case is made out in the plaint, has to be substantiated and proved by the plaintiff.
That's right.
That is also the one of the ingredient to record the finding. I will just show from para 23 of the trial court judgment, where the boundaries, what my learned friend rightly admitted, in respect of item number 2 to 10, there are only 2 boundaries. That is an admitted position on their behalf also, and as per the trial court also said about the same. But so far the other items are concerned, what is the discussion by the appellate court and what is the discussion by the trial court? I will just
Item number 2 to 10.
they
just
say
have a
there
look
are
at
only
it.
2 boundaries.
No. Item number 2 to 10, Schedule A, it
That
is
is to
giving. It is giving all the 4 boundaries.
That is to be seen from the hukumnamas which have been
So
described.
therefore, I want to know,
Yes.
so far as defect in plaint is concerned,
Yes.
that is not correct.
That may not be. That
So
may not
Order
be.
7, Rule 11,
Rule 3.
Order 7, Rule 3.
3.
At least that stands satisfied.
Your Lordship may kindly see that is not the sole
See,
ground
That is.
to dismiss
No,
the
maybe. But when
I am
when
just
there
coming
is
to
a
that.
when there is a specific issue framed by the learned trial court as
Yes,
well
ma'am.
as the appellate court
Yes.
as to whether the suit is barred by Order 7, Rule 3,
Then your
right?
Lordship may kindly
Then
come
how
to-
the appellate court has come to a finding that the suit was barred by order
Now,
7
I am coming to that one issues, my lord, which have been framed.
Yes.
Subject to Lordship kind present those were quoted in the appellate court judgment also.
Order 7 rule 3.
Your Lordship just see, my lord.
Issue number 5.
While deciding order 7 rule 3, the appellate court has referred to this section 44 of Chotanagpur Tenancy Act.
Which is the
Does
requirement.
it? No, which is the requirement under Chotanagpur Tenancy Act.
For Hukumnama.
Maybe for Hukumnama.
Hukumnama,
But
which
for
they
the
base.
that's right. But for the purposes of a plaint,
Order 7 rule 3.
or section 44 of Chotanagpur Tenancy
Section
Act is not the
44 has been
requirement.
referred to
What is
only because the
important?
Hukumnamas.
What is important in the plaint is that it should be an identifiable property.
Yes, that
Right?
is the only
And the
purpose.
identity of the property
Yes.
has to
If it
be
is
some
distinct.
boundary, some plot number, etc. has
That
to be
has been
given
dis-
in the plaint.
The boundary which has been given in the plan, and as per the schedule A of the plan, that has been very minutely discussed by the learned trial court.
Where
And
is
it
that
was found-
discussion? You see,
Yes,
when
I
it
just-
comes to first appellate
Yes,
court, the
first
first
of all,
appellate
madam-
court is also required to do that needful. You see, the trial court has given such a detailed
Discussion with regard
discussion
to each
with
of the
regard to each of
Hukumnamas,
the.
and also found that the boundary which was given by them, not at least not in the cases
Where
where
is-
four boundaries are
Where
there.
is the discussion
Yes,
of
there are
evidence by
23
the
first-
learned
Para
First
23
appellate.
of the trial court judgment I
merely
first-
because the trial court has discussed all the evidences?
I'm
That
just-
does not
I'm
mean that
just
the
coming to that.
appellate court will
I
not discuss the
I will
evidences.
also meet the said queries also.
Yes.
And also, first of all, I am permitted to place under para 23. Then I will come to appellate court judgment para 13. Para 23 which I have already read.
नहीं वो अब पढ़ लिया सर
हमने- हम
ट्रायल
ज़्यादा
कोर्ट
नहीं
का
पढ़े।
जजमेंट दोबारा मत पढ़िए
नहीं,
इसका कोई
दोबारा
जरूरत
नहीं पढ़ना बोलो, उतना ही रेलिवेंट क्वेश्चन पढ़ना है. Why the trial court disbelief कि बाउंड्री में जो दे रहे हैं, तो मेरा ट्रायल कोर्ट का कहना है कि उनका
नहीं
निजी
कॉन्करेंट फाइंडिंग कहाँ है appellate court का वो
है.
देखिए
हम आ रहे हैं.
बस appellate
आ रहे
court
हैं,
का
बस
कॉन्करेंट फाइंडिंग देखिए
एक लाइन सिर्फ हम पढ़ देंगे. पैरा 23 का भी ये पेज नंबर 11 में पैरा एग्जिबिट 6 सीरीज का डिस्कशन है with reference to the evidence adduced by them, and ultimately your lordship just kindly see why the trial court disbelieved.
सर आप ट्रायल कोर्ट में क्यों अड़े हुए
आ रहा है appellate court को भी.
आप ट्रायल कोर्ट को तो हम जान रहे हैं कि बहुत सारा
डिटेल
एविडेंस
में
डिस्कस
लिखा है,
करके अपना
जिनका
detail-
बाउंड्री को गलत पाया, that has been held.
हाँ, ठीक।
Now your lordship may kindly see para 13 of the appellate court judgment. It starts from para 12 minute, the discussion 5, 6 and 7 including order 7 rule 3. The lordship may kindly see the suit land is a para 12 I am reading for it. Suit land is a Kutkati Jamindari land. The father of the Ram Sevak Mato, namely Peku Mato, was Diwan of the Kutkati Jamindari. Even the original plaintiff number 1 Ram Sevak Mato issued rent receipt marked exhibit 6 in favor of the defendant, meaning that the plaintiff was related with the landlord. Para 3, para 2 of Khatian described that without prior permission of the landlord, no renter can reclaim land. The Honorable High Court, I am skipping now the next page. Plaintiff appellant have claimed entire land mentioned in Schedule A of the plaint. There are 14 items of Schedule A of the plaint. Item number 1, 2, 3, 4, 5, 6, 7, 8 and 9 and 10 were settled to Pekumato by Kutkati Jamindar. Item number 11 and 12 were settled in favor of Ram Sevak Mato by Kutkati Jamindar. And item number 13 was settled to Govind Mato. But item number 14 has not been discussed in the plaint. There is some confusion regarding Exhibit 6. The learned court below has considered Exhibit 6 beyond the description of the plan. That is the description para 23 of the trial court judgment, why I was referring. There is some distance regarding Exhibit 6 by B and 6 by E also. These exhibits do not match with the items mentioned in the schedule of the plan, and that is the discussion detail in the trial court. Each and every hukumnama and the schedule appended to the plan have been comparatively studied by the learned trial court, considered by the learned trial court, and it has been mentioned, and the appellate court also In gist, it has been
The
recorded.
appellate court says that the trial court has considered it. Where is the independent
Again I am
consideration of the
coming.
learned
Again I am
appellate court?
coming. Again I am coming. Only two these exhibits means not 6 by B and 6 by E also. These exhibits do not match with the items mentioned in the schedule of the claim. Only two boundaries have been given by the Hukumnama, but the learned advocate of the respondent submitted that only two boundaries have been mentioned because Khatian bears only two boundaries. The dispute between the parties in regard to entire land, but the plaintiff has stated the proceedings. I am skipping. Then, para 13. Both the parties have filed Sada Hukumnama Exhibit H2 series, the Sada Hukumnama in the year 1956, Exhibit 6 Hukumnama of 1952, one of the Hukumnama of the defendant in the year 1932. Then I am skipping order 7, rule 30, rule 3. Then kindly come to page 8. The learned counsel for the appellant has filed certified copy of R.S. Khatian, Khata number 167, plot number 688 on 1/10/2015, and the learned counsel for the respondent has given no objection on the petition filed by the appellant on that day under order 41/27. The certified copy of Khatian is attached with the record, and it appears from the perusal of the certified copy of Khatian of 167 Khata are found plot number 688 and has 98 acres of land. The area of each item of the land mentioned in the schedule of the plan is essential for preparation of decree. Both the parties are claiming their right through hukumnamas and they have paid rent to the landlord. The hukumnama of the defendant respondent begins from the year 1932. Even Exhibit C, which is in rent receipt in favor of the defendant respondent, have been prepared by original plaintiff number 1. Rent receipt has been issued as a diwan by the plaintiff number 1 to the defendant. And the admitted position is that original plaintiff number 1 and his father Pepu Mato were diwan of Khatiani landlord. The lands are scattered and plaintiff Govind Mato has stated that the suit land is situated only on two places. The statement of PW3 Asutosh Mahato, discussion with regard to oral evidence. PW3 Asutosh Mahato deposed in his cross-examination that the plaintiffs cultivates separately. The plaintiff number 2 Govind Mahato has deposed that in the year 1956 he was a student of class 4, and then he has stated his age was 58 years in 2007, and he has reclaimed the land in 1939 to 45. These facts create doubt over the claim of the plaintiff public appellant, and accordingly findings of the learned court below does not want interference. Discussion with regard to PW3, discussion with regard to PW2, plaintiff number 2, discussion with regard to the Exhibit 6, and discussion with regard to Exhibit C. There are two reasons which have been assigned. Number 1, the Hukumnama in earlier in point of time belongs to the defendant. Number 2, plaintiff number.
So you are not claiming the entire property, are you?
Yes, we are claiming on the basis of our Hukumnama.
No, whatever. No. You are not claiming the entire schedule.
That has been recorded. Now, my humble submission to that effect is the plaintiff can succeed on his own case, not the weakness of the defendant. The court cannot pass a decree on the admission on the part of the defendant unless the plaintiff proves his title free from all doubt. Therefore, both the courts have found, after discussing the oral and documentary evidence, of course, trial court in detail, appellate court sweeping so. I'm just sorry, trial court in details and appellate court also. Appellate court also discuss.
ट्रायल कोर्ट का जजमेंट पढ़ के एक फाइंडिंग रिकॉर्ड करना एक बात है और एविडेंस पढ़ के एक फाइंडिंग रिकॉर्ड करना अलग बात है।
PW3 में पढ़ा है तो
उतना PW3 का खाली एक एविडेंस देखने से हो जाएगा।
Plaintiff number 2, he is the plaintiff number 2, yes. And there is no explanation, my lord, that the plaintiff number 1, being diwan, he issued the rent receipt to the defendant. Number 1, number 2. Hukumnama of the defendant is of year 1932.
This the kind of the manner in which the first appellate court has decided the judgment. एकदम नहीं चलेगा.
Your lordship may kindly appreciate, in a case of affirmation of a
सर
judgment
देखिए
and
एक
decree.
चीज बता रहे हैं,
जी.
ठीक है, जहाँ इतना ज़्यादा ओरल एंड डॉक्यूमेंट्री एविडेंस का इन्वॉल्वमेंट है, ठीक है,
है?
then under such circumstances it is certainly the duty of the appellate court to discuss the oral and documentary evidences. Where the findings are to be based on these documents, those evidences are to be independently considered. It is one thing to say that the appellate court also comes to the कोई legal issue है मान लीजिए, तो इस यह मान लीजिए कोई इतना ज़्यादा evidence नहीं है,
The entire issue based upon the oral and documentary evidence.
दोनों है ना सर, तो
Oral and
कोई
documentary
oral and
Therefore,
documentary
the-
evidence का कहाँ discussion है?
A
first
minute
appellate court?
discussion by the trial court. What has been emerged?
Sir, देखिए
In
minute
the judgment
discussion
of the
by the
trial
trial
court.
court,
Now
and
the
the
appellate
appellate court says that yes, I have also seen it. This is how it is.
Yes,
It has been
That is
recorded.
the reason I was referring para 13, 12 and 13.
This is absolutely not satisfying.
Para
ये
13
थोड़ा
में भी
शॉर्टकट में कर दिए, इतना
करके,
शॉर्टकट।
लेकिन उतना ही की जितना जरूरत है.
डिफेंडेंट का तो
जरूरत था.
तो भी
अब तो जो सेकंड अपील में हो जो तो और शॉर्टकट.
वही ना, उसी शॉर्टकट को आपका सब्सटेंशियल क्वेश्चन ऑफ लॉ ही ऐसा बना हुआ है कि जहाँ शॉर्टकट का कोई स्कोप नहीं। हमको देखिए सेकंड अपील में तो हम फिर से एविडेंस पढ़ के कोई फाइंडिंग नहीं
Yes,
रिकॉर्ड
my humble
करेंगे।
submission is that.
I will not do that, right?
Because
But at least the first appellate
My
court,
learned
which is
friend may point out if it is a perverse finding.
not
The
necessary.
appellate court
You
judgment.
see,
Then
not-
your lordship
not
may
necessary.
may right.
when
May be
when
right.
there is a concurrent finding after appreciating the material on record, then he has to show some perversity in the matter of appreciation.
Now,
When the
the
first
finding-
appellate court
let us-
has, आप बोलते हैं numerous documentary evidences and oral
Yes,
evidences are there.
but those
Where
have
is
been
the
referred-
discussion?
Those have been referred to, of course, in short. I admit.
Too
But
short.
para 12 and 13 are the reply to
Shortcut.
those
is-
queries. Para
इतना
12
short
and 13.
circuit.
Short query.
Short
para
circuit.
12 and 13 में खुद लिख रहे हैं हम लोग क्यों ऐसा
ये
finding.
जजमेंट को हम लोग अपहोल्ड नहीं।
Thus, facts create doubt
नहीं,
over
नहीं
the claim of the appellant, and according to the findings of the
नहीं
learned
कर
court
पाएंगे,
below,
Mr. Sani।
does not want to inter.
आप इनकी तरफ खड़े होकर
हम भी
सोचिए।
वही बोलते हो जो नहीं जो इनके तरफ से होते तो भी हम अपना तरफ का बात ही बोलते हैं कारण बता रहे हैं
सर देखिए
Law
कम
ही
से कम ठीक है, you see,
one thing more they say and has been recorded that we do not have any claim over certain items. Number one, they also say that I have
sir
no, I
एक चीज,
don't have
sir
any
just
better case.
just a moment, they do not have any claim under certain items. Is there any finding by the learned first appellate court कि ये जो claim है जो जिस पर आपका कोई claim नहीं है, they have not been able to make out a case?
उनका तो कहना है कि एग्जिबिट 6 सीरीज जो उनका हुक्मनामा है
ऐसा नहीं।
उसके बारे में ही लिखे हैं।
आपका जो ये जो फाइंडिंग रिकॉर्ड कर दिए हैं कि आइटम नंबर 14 का प्लेन में कोई जिक्र नहीं है, दिस इज एब्सोल्युटली परवर्स। ये देखिए पैरा 11 ऑफ द प्लेंट हम खोल के बैठे हैं। हमको लगता है कभी कभी क्या होता है ना सर, हम आपको बताते प्रैक्टिकल चीज, जहाँ रिटन सबमिशंस फाइल होता है ना वहाँ बहुत घोटाला हो जाता है। उसमें क्या होता है कि रिकॉर्ड टैली नहीं हो पाता,
माइंड
इसीलिए रिटन सबमिशन इज अ माइंड गेम।
मुद्रा तकलीफ काहे करेंगे माइंड दिया हुआ है
बस लिखा हुआ है कि नहीं डिस्क्रिप्शन है तो उसको लिख ही देते हैं कि नहीं डिस्क्रिप्शन है ऑन द फेस ऑफ इट। अब देखिए पैरा 11 ऑफ द प्लेंट, जिस केस में रिटन सबमिशंस फाइल होता है ना ट्रायल कोर्ट या एपेलेट कोर्ट, उसमें बहुत ज्यादा अलर्ट होने की जरूरत है, क्योंकि उसमें चांस यही होता है कि रिटन सबमिशन से
हो रहा
कॉपी
हो, कोर्ट का ड्यूटी बनता है रिकॉर्ड में जो आया हुआ मटेरियल्स उसको एग्जामिन करें। तो
इसलिए
duty
जब
बनता
आप
है।
लोग रिटन सबमिशन फाइल करते हैं तो एक हफ्ता हम उसको टैली करने में लगाते हैं,
बिना टैली की होगा कि नहीं सर, उचित
लेकिन
नहीं
वहाँ नहीं होता है।
उचित नहीं होगा।
आप हमको बताइए ये कैसे लिख दिए हैं कि मतलब सीरियल नंबर 14 का प्लेंट में कोई जिक्र नहीं है। देखिए पैरा 11 पढ़िए तो।
यस Number 1167, Sachin sir, the defendants are still in.
ये है ना orally settled 1.33 acres of land out of RS plot number 688 of खाता number 167 of the said village more fully described in item number 13 of schedule A. ये item number 14 में है ये description.
13.
14 में. आप देखिए plaint का 14.
Para 11 में जो लिखा है कि the learned counsel for the appellant has raised objection on the findings of the learned court below regarding issue number 6-7. Now issue number 5-6-7 are being discussed. Appellate court का para 11.
हाँ.
तो उसमें तो जो 14 के बारे में 11 में है जो कि learned counsel for the appellant has raised objection on the findings of the learned court below regarding issue number 6 and 7. Now issue number 5, 6, 7 are being discussed. तब पैरा 12 आता है. पैरा 12 में तो ऐसा कुछ नहीं. पैरा 12 में पैरा page 7 is the relevant. Item number 1 to 10 were settled to Koku Mato. 11, 12 were settled to Ramsevak Mato. And item number 13 settled to Govind Mato. But item number 14 has not been discussed in the plan.
तो जो item number 14 का जो ये description है,
उसका discussion के बारे में कर प्लेन का बॉडी में 13 तक तो दिया है, डिस्कस किया. पैरा 1 से लेके फिर आइटम वाइज डिस्कशन तो पता नहीं अपडेट कोड में रही जैसा गलत देता है. प्लेन का हुजूर देखा जाए आइटम वाइज डिस्क्रिप्शन स्टेटमेंट ऑफ प्लेन शेड्यूल अलग चीज है.
एग्जिबिट बताइए, एग्जिबिट 6/E बताइए कौन सा.
प्लेन में आइटम वाइज डिस्कशन नहीं है.
एक एग्जिबिट 6
गलत नहीं बोला.
एग्जिबिट 6/E कौन सा.
एंड में कोई डिस्कशन नहीं है किस आइटम को कैसे नहीं. शेड्यूल अलग चीज.
एग्जिबिट 6/E कौन सा. एग्जिबिट 6/E is for how much property.
Six by D.
6/D भी दिखाइए. नहीं, 6/B दिखाइए और 6/E दिखाइए.
Six by D पहले दिखाते हैं.
ठीक है, 6/D पहले दिखाइए.
मानकी घोषण से
एरिया बताइए.
नमस्ते.
हाँ, हुक्मनामे में बताइए.
मानकी क्षेत्र मोहम्मद मुंडा भूमि खेती जमींदारी शकीन जामुन बड़ी स्वतंत्र आगे मनमुखी व्यवस्थित प्रकार से 420 निकला. नाम सेवा महतो वंश कुटुंब महतो जात पेशा खेती बाड़ी शकीन मोजा प्रणय हिना तमा जिला रांची के मात नगर सलामी मजकूर कायम कर मोदी प्रति नाम के उच्च प्राप्त 50 आबाद होके को मजा ग्रामीण पीढ़ी बढ़ने स्वतंत्र रजिस्टर में रजिस्टर में छोटी जिला के वाक़े नौकरी सलामी मालगुजारी ₹4
नहीं, आप उनको सिर्फ 6/8 मतलब
ठीक है उसमें तो
आप इसलिए पैरा 13 एंड ये आइटम नंबर 13 एंड 14 में आइए। इसमें लैंड मेजरिंग 1.33 एकर्स आउट ऑफ आरएस प्लॉट नंबर 688 खाता नंबर 167, लेकिन 13 एंड 14 का बाउंड्री दोनों का अलग अलग,
13 and 14
हाँ, सीरियल नंबर 13 एंड 14, खाता नंबर सेम है, एरिया भी सेम है, प्लॉट नंबर भी सेम है, लेकिन एरिया दोनों का अलग अलग है। तो हम ये जानना चाहते हैं कि सीरियल नंबर 14 आपने बोला 6/E से गवर्न है, तो 6/E का खाता नंबर, प्लॉट नंबर और एरिया क्या है?
6/D भी आप एक बार पूछ लीजिए 6/D लिखा है
6/E
जिसका खाता नंबर 167 प्लॉट नंबर 688 मध्य रकबा 133 जिसका चौहदी उत्तर में नहर सीधाम आपको दक्षिण में मनसुख महतो व पंचम
ये 6/E पढ़ रहे हैं,
6/B पढ़
6/B तो ये हो गया सीरियल नंबर 13 का, ठीक है, और 14 का बताइए, यानी कि 6/E का बताइए।
6/E का है जो इसमें 167 प्लॉट है, खाता नंबर 167 प्लॉट नंबर 688 मध्य रकबा 133 जिसका चौहदी उत्तर रंजित महतो व रामेश्वर महतो, दक्षिण कुसुम महतो, पूरब तांग, पश्चिम दोनों देवेंद्र नाथ, पूरब दोहरा महतो, पश्चिम दो क्या
देवेंद्र नाथ सिंह, ये हुआ 6/E।
डिटेल्स
और इसका डेट क्या है?
इसका डेट है 9/5/73। हर जगह दो बाउंड्री नहीं है, सब में तो 4 बाउंड्री है, अपरेंट है, हुक्मनामा से भी अपरेंट है। वो फाइंडिंग तो कम से कम एकदम ही परफेक्ट कि 2 ही बाउंड्री है करके इसको पूरा
ऐसा नहीं है, ट्रायल कोर्ट के फाइंडिंग को सपोर्ट किया।
अच्छा,
ट्रायल कोर्ट क्यों किए हैं?
कोई बात नहीं, जजमेंट सुनिए।
ट्रायल कोर्ट का जजमेंट को देखेंगे, अगर उसमें गलती होता तो इनका गलती है।
सर इस तरह से
इसीलिए
एपिलेट कोर्ट को
one thing I
मतलब
should
ट्रायल
make it
कोर्ट
clear.
के
One thing I should beg to make it clear. The learned appellate court found and observed that item-wise properties have not been described in the plan. That is his contention.
That's
It is not that the schedule. He does not say about the schedule. The paragraph 11, what your lordship read it, Lord. That is, he says with regard to the description of the land in the plan, schedule is something else.
schedule also forms a part of the
Yes,
plan.
but it is to be how they have acquired. I do not say that every evidence is to be pleaded, but at least the acquisition or source of acquisition
That's
by referring the particular hukumnama, particular plot and area, and which must tally with the schedule. That is the observation of the learned trial court. That he says. And secondly, my lord, para 23 of the trial court judgment is the answer to these queries. Now, para 23 and 24 very minutely discussed that the boundary which was given, even 4 boundaries, those were not telling with the actual position of the land, and that is from the oral evidence laid by them, the plaintiffs, and that has been recorded that it does not tally, and therefore the created doubt, and therefore the learned trial court did not disbelieve the case of the plaintiff. That is the case. For the weakness of the defendant, plaintiff cannot succeed. He has to prove his own case. section 44 relates to the hukumnama. What should be the contents of the hukumnama? That is section 44. No finding as such has been recorded by the learned appellate. Quoted it.
देखिए सर, जो आइटम नंबर 13 है उसका डिस्क्रिप्शन ऑफ प्रॉपर्टी है एग्जिबिट 6/B में. आइटम नंबर 14 का डिस्क्रिप्शन ऑफ प्रॉपर्टी इज इन एग्जिबिट 6/E. The date of two exhibits are also different. Plaintiff may he has specifically referred to exhibit 6/E, which is of the year 1973. There is a specific reference to that, right? Merely because item number नहीं लिखा है, इससे this will not decide the entire fate of the
That
case.
is only one of the grounds.
अगर जितना हम लोग इतना एक्सरसाइज किए ना, अगर इतना भी एक्सरसाइज एपिलेट को कर लेते ना, तो ये फाइंडिंग नहीं आती. इतना मतलब 5 मिनट वाला एक्सरसाइज था करना था.
That was not the sole ground to dispute.
That is not the sole ground, but it creates a
But this is
very.
one of the grounds.
अगर इस तरह का फाइंडिंग हमारे एपिलेट कोर्ट के पास से आ जाएगा, तो इससे क्या what impression am I getting of the appellate court's exercise of power under first appellate jurisdiction?
There should have been point for determination. There should have been
फिर कम से
finding
कम-
each point twice.
एक एक
And that is-
हुक्मनामा का रेंट रिसीट के साथ टैली नहीं टैली, ओरल एविडेंस, बाउंड्रीज, ये सब चीज का फाइंडिंग
at least
डिस्कशन
summarily discuss करना चाहिए.
एकदम से
और ऑर्डर 41 रूल 31 सीपीसी भी वही बोलता है.
नहीं.
ऑर्डर 41 रूल 31.
इसीलिए कि कब अपील होइएगा बस ये बताइए. नहीं चलता सर ऐसे किसी का जमीन को लेकर इस तरह से.
किसी का मैं हमरा है कि उनका है वो तो जो नहीं
वो तो
कहेंगे.
नहीं, हम तो कहाँ डिसाइड कर रहे हैं
ट्रायल
किसका,
कोर्ट जजमेंट भी मेरा
कहाँ डिसाइड
आज
कर
भी
रहे
मेरे
हैं
ही
किसका,
हक में है.
कहाँ डिसाइड कर रहे हैं किसका है, नहीं डिसाइड कर रहे हैं ना. बोल रहे हैं उनको कि डिसाइड करिए, एविडेंस को देख के डिसाइड करिए. दैट इज ऑल.
ट्रायल कोर्ट का जजमेंट गलत था कि सही था, एटलीस्ट वही उनको उनसे रेफर
ठीक से
करके
थोड़ा सा
देना.
रेफर करके एक थोड़ा सा डिस्कशन करते तो बहुत स्केची है और लग नहीं रहा है ऐसा देखकर कि एविडेंस को खोल के देखा है. इतना दिन से सेकेंड अपील में बैठ है, थोड़ा आइडिया हो गया है कि एपिलेट कोर्ट के यहाँ क्या क्या. इसीलिए देखिए आपको हम बता रहे हैं, मेरा सेकेंड अपील का भी जजमेंट बहुत डिटेल्ड होता है, ओनली बिकॉज ऑफ दिस
उसी का जजमेंट डिटेल.
इसी वजह से बिकॉज आई एम कॉन्शियस ऑफ द फैक्ट कि फर्स्ट एपिलेट कोर्ट में क्या चल रहा है.
इसीलिए रेफर कर रहे थे ऑर्डर 41 रूल 31. इसमें कहता है कि पॉइंट्स फॉर डिटरमिनेशन शुड हैव बीन framed, then each point should have been discussed separately by with reference to the, because it is a final court of fact. फाइनल कोर्ट ऑफ अब हम जो लॉ कहता है वो कोर्ट, हम डिफेंडेंट की तरफ से नहीं, एज ए लॉयर हम टू असिस्ट दिस कोर्ट कि व्हाट शुड बी द
हमको पता है आपका तो करियर ही सिविल लॉ से शुरू हुआ है,
रिक्वायरमेंट.
सो इसीलिए यू आर एन एक्सपर्ट इन सिविल लॉ. आई नो
जानते हैं नहीं बोल रहे, लेकिन ऑर्डर 41 रूल 31 यही कहता ही है जो हुजूर बोल रहे हैं एपिलेट कोर्ट के बारे में. तो दैट इज द बेसिक रिक्वायरमेंट.
सेकंड
आई कैन नॉट
अपील
add anything more which is not on there.
Second appeal number 65 of 2016. Heard the learned counsel appearing on behalf of the parties. This appeal has been admitted for final hearing by the order dated 18/4/2024 on the following substantial questions of law. वो तो लिखाए थे, उनको लिखाया था ना. आपके आँख में फिर से प्रॉब्लम हो गया है. अरे फिर किसी और को भेज देते, मतलब फिर से रेफर कर गया प्रॉब्लम.
हाँ फिर से
तो घर जाइए. हाँ आप किसी को भेज दीजिए घर जाइए. आप किसी को भेजिए. कुछ बोलते तो है नहीं, तबीयत खराब हो जाती है। आँख में कुछ प्रॉब्लम हो गया है, अभी एक कोई अदर स्टेट का, सॉरी थोड़ा सा रेस्ट की ज़रूरत है।
बात है बरसात का, इसलिए मौसम तो चेंज हो
बहुत बरसात हो रहा है, एकदम गर्मी हो गई।
खांसी का एकमात्र चुप दवा है लौंग को अगर गर्म करके जीभ के नीचे रखा जाए, खांसी नहीं होती। बहुत बहुत अच्छी दवा। थोड़ा सा हल्का तावा में गर्म करके लौंग एक लौंग और फिर चुन में गर्म करने के बाद इसे ठंडा रखेंगे, उसको अगर दे देंगे खांसी रुक जाएगी। बहुत हम देख चुके हैं। आदि लेने से क्या होगा, कफ जम जाता है, लौंग में नहीं जमता।
My case, you should make pass with judgment regarding the sending the matter to elect court. In which some of the judgments is also relevant for this. Manjula case that appeal
मिस्टर
was
शर्मा,
arising
उस
out of
मैटर का क्या हुआ जो एक
that was arising out of a reverse, though it's a concurrence.
उस मैटर का क्या हुआ? आई जस्ट वांटेड टू नो। एक सरायकेला का एक जमींदारी का कुछ केस था।
अच्छा, एक मैटर था,
वो गया है सुप्रीम कोर्ट, क्योंकि एक और मैटर उस तरह का आया था। केस का नंबर थोड़ा बताएंगे, क्योंकि कोई एक व्यू लेने के बाद तो फिर देखना पड़ता है।
फर्स्ट अपील
नहीं, सेकेंड अपील।
वो तो मैंने किया था।
आपकी कैसे?
नहीं, तो फर्स्ट अपील मैंने किया था। फर्स्ट अपील था सर,
आपको जिताए कि थे? तो यार नहीं,
नहीं फर्स्ट अपील था।
फर्स्ट अपील
अखिल मंडल वेरी एलैबोरेट जजमेंट उसमें सीएनटी और बिहार लैंड रिफॉर्म्स एक्ट,
हाँ, और वहाँ का कौन सा लोकल लॉ फर्स्ट अपील,
उसमें पटना हाई कोर्ट का दूसरा जजमेंट हम लोग बिहार लैंड रिफॉर्म्स एक्ट,
हाँ कुछ था उसमें।
उस पॉइंट पे बहुत लैंडमार्क जजमेंट हुआ है।
नहीं, बात ये है लैंडमार्क जजमेंट के साथ रिस्क बहुत है, क्योंकि अगर मान लीजिए उसको हम ऐसे फॉलो करते हैं और हम उसको ये नहीं फॉलो करते हैं कि अल्टीमेटली सुप्रीम कोर्ट तक गया कि नहीं गया, तो इसीलिए थोड़ा सा ध्यान रखना जरूरी है।
हमारे समझ से जो पॉइंट ऑफ लॉ ऑनरेबल जस्टिस पीएस मिश्रा साहब ने उस केस में लिया था, बिहार लैंड रिफॉर्म्स एक्ट का उसका प्रोवाइजर मुझे भी इंटरप्रेट किया।
खाली केस नंबर हमको दे देंगे, बाकी हम ट्रैक करेंगे। लिखिए बिल्कुल जी, कुछ पार्ट लिखा है तो
188 of 2018 फर्स्ट
लिखिए, तो नंबर लिख लीजिए।
फर्स्ट अपील 188 of 2018।
देखिए ऐसे नंबर 65 of 2016 or the learned counsel appearing on behalf of the parties, this appeal has been filed against concurrent judgment this appeal has been filed against the judgment dated 6th of October 2015 within bracket decree signed on 14th October 2015 bracket rules passed by learned additional Judicial Commissioner Roman 7 Ranchi entitled appeal number 125 of 2009 slash trial number 01 of 2014, whereby the learned First Appellate Court has dismissed the title appeal and has affirmed the judgment dated 11th August 2009 within bracket decree signed on 19th of August 2009 bracket close, passed by learned Munsif Kuti in title suit number 12 of 2004. This appeal was admitted by order dated 18/4/2004 on the following substantial questions of law. The learned counsel for the appellant, while referring to the first substantial question of law, has submitted that the judgment of the of the trial court itself would reveal that there were numerous documentary and oral evidences led by both the parties with respect to their claim and both the parties were claiming property through hukumnamas, although the entire property mentioned in Schedule A was not overlapping. The learned counsel has submitted that the learned counsel has also submitted that the parties had also placed rent receipts with respect to their respective claims. He submits that as many as 9 issues were framed by the learned trial court, including issue number 5, 6 and 7, which are as follows. इसको quote कर देंगे. The learned trial court, after consideration of materials on record, has decided the issues against the plaintiff he has referred to the trial court's judgment to submit that with respect to the identity of the suit property, oral and documentary evidences were subject to consideration. And so far as the plaintiff is concerned, there were altogether 14 items in Schedule A property, and on the basis, and the suit property was identifiable on the basis of the description in the plaint read with the description of the property in the hukumnamas and supported by the oral evidences. But the evidences were not properly appreciated by the learned trial court, by holding that the suit itself was not maintainable under Order 7 of CPC. And while rejecting the claim of the plaintiffs, he has also submitted that with respect to possession, the learned trial court only primarily considered with regard to possession also, the finding were against the plaintiff, but that was also by considering the oral and documentary evidences. He submits that since the evidences were not properly considered, an appeal was filed, and before the first appellate court, though no separate point of determination were framed, but the first appellate court primarily addressed the issue number 5, 6 and 7 as framed by the learned trial court. The learned counsel has submitted that the discussions made by the learned first appellate court reveal that although the first appellate court has referred to the findings and discussions as some of the findings and discussions as recorded by the learned trial court, but so far as the oral and documentary evidences on record are concerned, there is no independent application of finding.
No discussion with the defendants in that sense.
He has also submitted that there is no discussion of the evidences led by the defendants also. The learned counsel has also submitted that the learned first appellate court has recorded that both the parties were claiming through hukumnama, and the hukumnama of the respondents began sometimes in the year 1932, but the records would reveal that the properties were not, the properties claimed by the defendant were not the identical properties, were not fully identical, even as per their claim through hukum. The learned counsel has submitted that on the face of the plaint and the description of property in the plaint, it could not have been said to be hit by Order 7.3 of CPC.
Many properties they are not living.
I'll just come to that. I'll come to that. The learned counsel has also submitted that the point regarding possession has been primarily considered with respect to the proceeding under section 145 of CRPC, and there is no further discussion of oral and documentary evidences in connection with the same. The learned counsel has submitted that in a case where the matter has to be decided on the basis of both oral and documentary evidences, the appellate court was under a duty to consider the oral and documentary evidences independent of the finding which was recorded by the learned trial court. It could be possible that the appellate court could also arrive at the same findings, but independent application of mind should reflect from the judgment itself. He submits that the perusal of the judgment passed by the learned first appellate court reveals that the exercise of power by the first appellate court has not been done in accordance with the mandate. With respect to second substantial question of law, the learned counsel has submitted that The first appellate court has not returned any finding with respect to item number 2, 3, 4, 6, 9, 10 of Schedule A property, which was not even claimed by the defendant, and this finding has been also recorded by the learned trial court in its judgment that the defendants are not claiming the aforesaid property, for which he has referred to the trial court's judgment at para number at internal page 18. The learned counsel has also submitted that para 23. Exhibit 3 क्या था? What was
Page 10.
page? Internal page 10.
Page 10. Para 23. 12. इस प्रकार आइटम
Internal page para 23 of trial court judgment, internal page 10. ये exhibit 3 क्या था?
Exhibit 3 is the judgment passed by the subdivision officer, where the position was declared to us.
Okay.
Take your losses before file.
हाँ, sure.
Though that when they went to High Court, that was set aside, and thereafter the direction was given that set aside on the point that as such no apprehension of peace. If the occasion will arise, then you may go for a proceeding under 145. That was started and that has been dropped.
The learned counsel has also submitted that with regard to possession, exhibit 3 has also not been properly considered by the learned first appellate court. The learned counsel has also submitted that the learned first appellate court has recorded that there was no description with respect to item number 14 of Schedule A to the plaintiff. He has submitted that item number 14 was referable to Exhibit 6 by E, which is dated 9/5/1973, and there is a clear mention of claim of the plaintiff on the basis of the Hukumnama dated 9/5/1973 within bracket Exhibit 6 by E. Merely because item number 14 as such, inverted comma has not been mentioned in the plaint, the same does not mean that the plaint did not cover the property which was covered by by item number 14, Schedule A of the plaint. The learned counsel submits that there is no finding by the learned first appellate court with respect to item number 2, 3, 4, 6, 9 and 10 of Schedule A. He submits that essentially the first appellate court has, he further submits that considering the nature of substantial question of law, it can certainly be argued that the first appellate court has not followed the mandate of Order 41 Rule 31 of CPC by deciding the first appellate. The learned counsel appearing on behalf of the respondents has opposed the prayer and has submitted that the learned trial court has elaborately discussed all the evidences on record and has given findings. The learned first appellate court, while dismissing the appeal, is not required to while dismissing the appeal, has referred to the findings recorded by the learned trial court and has also discussed some of the evidences on record. He has submitted that since the impugned judgment is a judgment of affirmance, therefore there was no further need by the learned first appellate court to discuss all the evidences on record. He has in particular referred to paragraph number 23 of the trial court's judgment. He has further submitted that the issue number 5, 6 and 7 has been duly considered by the learned first appellate court and has been decided against the appellant. The learned counsel has also submitted that the plaintiff has to stand on his own legs, and weakness of the case of the defendant will not be a ground for decreeing the suit. The learned counsel has submitted that the learned trial court ultimately came to a finding that the plaintiff has failed to establish their case, and therefore the findings having been affirmed by the learned first appellate court, the substantial questions of law are fit to be answered against the appellant and in favor of the respondents. After hearing the learned counsel, I refer.
Submitted. So it is a finding. It is not the finding. बस बातें हैं कि ऐसा केस है. But ultimate finding in para 30 and 31 it is not management submitted. It is a found by the learned trial court that it is not claimed. So
were you claiming?
You
tell us where you claiming.
We are claiming. We have said not that the plaintiffs have not have the right interest over the lands which we have been settled by virtue of Exhibit H series. Now it is a case of the plaintiff.
Does Exhibit H series
H
covers
yes,
item number 2, 3, 4, 6, 9, 10?
Which cover, and therefore you also just see for a moment. Therefore, it should be, when the trial court judgment is not being examined by this one, since the matter is going to be reconsidered by the appellate court, so it will be for the appellate court to decide. But this
उसमें
there
ऐसा
should
कर
not be
देंगे
any
ना,
wrong
finding मत रखिए,
observe.
has observed कर.
Yes, it will
ठीक है,
better.
पैरा 23 को खाली observed कर दीजिए.
Yes.
ठीक है. After hearing the learned counsel for the parties, it is not in dispute that both the parties were claiming their respective properties through hukumnamas. The plaintiff was claiming the Schedule A property by virtue of 5 hukumnamas exhibited as Exhibit 6 by A to 6 by E as mentioned above, and the defendants were also claiming the property, claiming certain portion of the property by virtue of independent hukumnamas. Both as contained in
H to H by 10.
H to H by 10, total 11 in numbers. Both the parties. Sorry.
Followed by rent receipts.
Followed by rent receipts. The plaintiffs also claimed and filed certain rent receipts before the learned court. Both the parties have adduced oral evidence with respect to identity and possession of the suit property. This court finds that the learned trial court has considered all the evidences on record and returned findings against the plaintiff. But when it comes to the learned first appellate court, this court does not find discussions of the oral and documentary evidences does not find discussion of the contents of the oral and documentary evidences as adduced by the parties, though,
No discussion of defendants.
and there is no discussion of
Defendants.
evidence of the witnesses of the defendants. The learned court, while deciding the issue number 5, observed that they held while holding that the suit was barred by Order 7.3 of CPC. Has not considered the materials on record as to whether the suit property was identifiable in law as per the evidences placed on record. From perusal of Schedule A, it appears that more or less boundary has been given with respect to the properties. Schedule A of the boundary has been given with respect to the properties. Moreover, this court also finds that so far as the possession is concerned, the court has primarily the first appellate court has primarily considered the dropping of proceeding under section 145 of CRPC, but has not considered the other evidences placed on record. This court finds that the present case is an intricate case for which required appreciation of both oral and documentary evidences on record. But the learned first appellate court has not discussed the materials independently and has primarily based its findings by referring to the trial court's judgment. And no specific finding has been recorded with respect to item number 2, 3, 4, 6, 9 and 10 of Schedule A. Consequently, both the substantial questions of law are answered again in favor of the appellant and against the respondents. However, the same would not be a reason to decree the suit in favor of the appellant, and the matter is required to be remitted back to the first appellate court for appreciation of for passing fresh judgment in accordance with law after following the mandate of Order 41 Rule 31. That should be sufficient. 2 महीने बाद का आपका appearance का date communicate कर दें, ठीक है. The parties to appear, सभी लोग appear कर रहे हैं यहाँ पर. All the parties are here. कोई ex parte तो नहीं है यहाँ पर. एक
हमारी तरफ से तो
the parties to appear before the learned first appellate court on September at 11 a.m. Since the suit is of the year 2009
To the successor
or to the successor court. Since the suit is of the year 2009, the learned first appellate court is directed to decide the appeal on the basis of materials already available on record as expeditiously as possible, and parties are directed to cooperate for early disposal of this.
Mandate of Order 41/31, my lord has passed this effect.
I will refer to
Regular
this.
case has been referred.
SA 28.
Para 18.
Okay, the learned counsel for the appellant has also referred to the judgment passed by this court in
2021 ACC 19 Supreme Court 1111.
in 2021.
Para 18 मुझे देखा है इस
वो citation बताइए.
citation
2022 volume 3 SSC 90. यही है?
जी 19 इसका इसमें ये भी करता है ये भी आउट ऑफ कॉन्फिडेंस था इसमें फर्स्ट अपीलेट कोर्ट ने इसका बिना कोई फर्दर एप्रिसिएशन के जजमेंट किया था जो हाई कोर्ट ने किया था उसके बाद मैटर सुप्रीम कोर्ट गया था उसमें ये जजमेंट है
ठीक. ये पैरा कोट कर देंगे इसमें.
para 17 में जो इसमें
उस जजमेंट का पैरा 17.
17 में ऑर्डर 41 to 31 का प्रोविजन
Discussion है
पैरा 8.
18
आपका
18 finding.
देखो जजमेंट इसी लिखा होता है जजमेंट एग्जैक्टली कंकरेंस से
हाँ. The first appellate court judgment is satisfied. Record से photocopy आता है. Record वहीं पर. हाँ, just all good.
Notified case for judgment item 1 second appeal 157 of 2019.
The second appeal is allowed. किसका था खबर कर दिए थे. किसका सेकंड अपील है? आपका है. किसका? पार्टी कौन है इसमें? क्योंकि नोटिस और इसको उन लोगों को नोटिस तो हो जाता है ना नोटिफाई करने से.
Item 5 first appeal 207 of 2023.
इसमें रिस्पोंडेंट को इंस्ट्रक्शन लेके बताना कॉलेज बनाने वाला
हाँ बताइए क्या करना आपको.
The instruction is that in principle they are ready, but so far as time frame is concerned, they say they can mutually discuss or it can be sent to
Mediation
mediation
ठीक है.
because it has to go to the committee and so timeline
That's-
may take some time to decide. The
I
committee.
send it to mediation.
हाँ.
First appeal number 207 of 2023. Learned counsel for the parties are present. Both the counsels on instructions from their respective clients have submitted that they are ready for mediation and there is a likelihood of settlement in the matter. Accordingly, let this matter be sent for mediation to Jhalsa. The learned secretary Jhalsa is directed to appoint a mediator. The parties to appear on
Next Monday, no, because they are DAV, they have to arrange, they have to private parties.
Monday. आज कितना तारीख?
आज 20 Monday.
मंडे में जी आप अपियर होंगे किस दिन आप बताइए आप ही तो अपियर होंगे
इस तरीके से हम करवा देंगे अपने
हाँ,
अपियर करवा देंगे मंडे
Monday.
नेक्स्ट
ट्यूसडे मंडे
मंडे
इसको ऑर्डर को अपलोड करना होगा the parties to appear before the secretary Jhalsa on Monday at 11 a.m. At 11 a.m. Post this case on 25th of August, awaiting the report of the mediator. 25th, 26th, supplementary was list.
Item 6, first appeal 154 of 2024.
In this matter, we have already submitted the notes of argument.
थोड़ा याद कराना पड़ेगा
Order number 9,
आई नो बट थोड़ा सा याद कराना पड़ेगा काफ़ी दिन हो गए इससे गैप हो गया बस आपने रिटन नोट्स ऑफ आर्गुमेंट जमा किया यू आर द
I am the plaintiff, only plaintiff, now appellant. My title suit was filed for declaration of force, declaration of nullity of sale deeds. 4 sale deeds executed by defendant number 1 in favor of defendant number 2, 3, 4. And that title suit has been decided by the trial court as partition suit.
हाँ ये तो था अब यह
हाँ,
ठीक है कहाँ है बताइए
finding
Page number 56.
कल इनका सेकंड आपका
in
आज से तो दिया है उनका मैटर कितना मैटर सीरियल नंबर बताइए सीरियल नंबर अच्छा और आईडी नंबर इसको परसों दिखाएंगे थोड़ा पढ़ के दिखाना
अच्छा एक समस्या निकालना था एक पेज का माइनस में काइंडली पेरुस पेज 55 रनिंग पेज 55
और द ब्रीफ
मतलब 54 रादर
दिखाएंगे आप लोग के सामने
यस यस बस
थोड़ा सा पढ़ के दिखाएंगे
हाँ वो ये एक चीज उससे में डिस्कशन हो रहा था इसलिए
हाँ,
माय ड्यूटी टू
Page 54, last paragraph, ka you concluding. Now, which one is correct? Because it was a statement in para 12 or of the amended prayer, para 9 of the plain. Para 12 of the 9A of the plain. Para 12 mentioned that the plot number 657 1 acre is allocated to the plaintiff, while para 9A stated that the plots is allocated to defendant number 1. So there appears inconsistency in the statement of the plaintiff. This anomaly is required to be dispelled. Therefore, the intention and objective of the suit in the light of totality of the matter is required to be taken into consideration and not just by words. The relief claimed by the plaintiff is to declare sale deed number such and such related to it, which is endorsed in para 12 of the plaintiff is correct and not para 9A. Had para 9A of the plaintiff be correct, then relief would not be have been asked. It is also to be noted that as per the provisions of section 58 of the evidence, the court in its discretion requires the facts admitted also to be proved otherwise by such admission. So the court is under the need to have certain documents to prove the actual partition by means and bounds. In absence of any such document after the said partition of 1965, it cannot be considered as to prove the actually know which plots of the land allocated to whom by way of partitioning the joint property. Further, as per the defendant's written statement, the schedule of the property, including the plot number 1811, is allocated in favor of father of defendant number 1. But defendant submitted documents of two sale deeds, 729 and 1300, wherein plaintiffs have sold the property under Khata 9 and plot number 1811 of to the area of 0.12 acres and the defendants have never challenged the sale deeds. Had the whole area of the plot had already been allocated in favor of defendant number 1 as per share and partition, then why did he not challenge the cancellation for the same? Furthermore, as per the rent receipts of plaintiff, it suggests the rent has been paid by the farmer for the entire suit land, also which is said to be exclusive possession of the defendant number 1. So it shows that the properties of two brothers are actually still joint. So my contention to place this fact was, my lots was, suppose the entire area was 1 acre, for example 1 acre. What he has done is, I have sold certain property, but the remaining portion was distributed half. So in the concluding part. But my contention, which I was going while perusing all the records, was he has also sold properties. So the cause of action of this case, declaring that the sale deeds have the entire right title interest over the suit land, is not correct. This was my thing. I have also incorporated in the written statement, written submissions. Because he has also sold certain properties. Had it been that I had only sold the properties, the things would have been different.
So,
Lawsuit has not been filed.
No, I agree that lawsuit has not been filed. So my case is that the first appeal shall be stopped there, and extra finding that 1/2 share should be allocated to him and not to him. His cause of action is not there, my case. That was my case for the entire suit.
ये हाफ शेयर वाला कहानी गलत है.
Yes, minus. That's my entire contention.
हाफ शेयर वाला तो इसलिए रहेगा कि क्रॉस सूट हैज नॉट बीन फाइल्ड. They have not challenged the seal deed executed by me.
That's right. But this is not a partition suit.
This is not a partition suit.
This is
And
not a
partition has been done by trial court.
Yes. So that could not have been done.
That should not.
But the finding of the learned trial court that
Court did
that they are, so far as sale deeds are concerned,
4 sale deeds executed by defendant number 1 in favor of defendant number 2 through 4 excluded, and thereafter partition will take place as per
that
finding.
is not correct.
That
That
is
is
not.
not.
That is not correct.
That
But
is
he
not
has also
correct.
Because
sold
whenever there is a you see, whenever there is a sale of undivided share of joint family property, then under such circumstances, actually the person who is selling is the owner of the
Yes,
property. He is
absolutely.
a co-owner of
Yes,
the
that's
property.
absolutely right.
Then under such circumstances, whenever the partition takes place, there has to be adjustment.
Yes.
I have to compensate him.
Yes.
Compensate, or maybe that those portions will fall in your
Exactly,
share.
yes,
And then,
but his relief was for claiming right title interest over the entire plot. That is not a suit.
That has already.
Cause of action is, that was my submission, Manis. Whatever, because this fact was missing.
and so far as the other portion of the finding is concerned, you are not aggrieved.
I am aggrieved by. Therefore, I have appealed. Therefore, I have filed appeal. But my submission before Lordship is that by deducting the share which has already been sold by the dependent, the trial
That
court
should
has-
also be
That
taken.
should be, everything has to
Yes.
go.
That will satisfy your
Yes.
concern.
Yes.
You have given that judgment, that undivided portion of the undivided share of the joint family property can be sold.
There's a section 44 of the TPS.
थोड़ा सा लेके आएंगे उसमें, क्योंकि it is a once the property is held to be joint family property and a part of joint family property, then sale deed which is sought to be sustained, right? Then we have to give a finding to that effect. So, and ultimately the respective shares and the adjustment of shares will depend upon the final partition as and when it takes place. There is also a judgment if an undivided share is sold, then the person to whom it is sold, he can sue for partition of the
Yeah,
land
that's
and
exactly.
earn. Where are exactly आपके
तो
exactly
but-
बोलने से
but-
हम नहीं
They
लिखे.
have not taken single step.
I have not taken.
May not have.
May not have. My
They can
kind-
still take steps.
my-
There is no bar.
My worry was, to be very fair, my worry was that on the previous occasion when we argued on length, this essential fact was missing, that he had also sold certain shares, and the case was that only I had share, and out of the remainder portion the property was distributed now.
That's-
But
So whosoever has sold the property,
Has
the
sold.
entire property will come in one lot, and then
In
but-
partition.
but
in
he has to
partition.
file a fresh
In
suit.
partition.
provided
Ah.
provided
he files a
partition
fresh
suit is
suit, but this
No.
cannot be adjudicated over here
such.
in a right title interest suit.
The dependent or
Get
plaintiff
those
may file
judgments.
partitions.
Get those judgments. 2-3 judgments are there on this.
I have
आज नहीं
submitted.
हो पाएगा।
I have
हाँ ना।
परसों ही।
लिखाना पड़ता है,
हाँ।
लिखाने का काम है पूरा।
I have
फर्स्ट अपील में
submitted-
तो
I have
ओरल
submitted-
एविडेंस कितना है?
Oral evidence का
Five and
minus
six.
5,
5
6.
and 6. 5 and 6.
कौन सा
Five-
मटेरियल एविडेंस है?
Minus both the plaintiffs and defendants have not been examined.
नहीं,
नहीं।
dependent number 1 has not been
हाँ,
examined.
वो main वही है.
Rather, the suit was contested by dependent number 2 to 4. Only dependent number 1 has filed WS. Thereafter, he has not proceeded in the matter.
Main plaintiff जो है.
हाँ. नहीं, main plaintiff तो
नहीं,
he
फर्स्ट
has
अपील
died.
में तो ओरल एविडेंस भी हमको डिस्कस करना
हाँ,
पड़ेगा ना।
पूरा-
आई एम
पूरा-
सपोज टू। तो
Yes,
आप हमको बताइए कौन सा मटेरियल एविडेंस है ओरल एविडेंस में?
Minus.
Plaintiffs are the witnesses, Lordship, and one independent witness appeal of the type Motika.
प्राइमरीली पोजीशन पर ही होगा एविडेंस, जॉइंट पोजीशन पर ही एविडेंस होगा।
Joint
बाकी तो
possession-
द प्रॉपर्टी इज स्टैंडिंग इन द नेम ऑफ
Joint-
कॉमन एंसेस्टर।
हाँ,
दोनों
joint-
मिलके co-purchaser. Both of them were co-purchaser. This is the entire case. Both of them were co-purchaser. Both were brothers.
Father,
And both were
father of-
co-purchasers.
Father of plaintiffs and defendants are brothers.
फ्राइडे को रखेंगे इसको। फ्राइडे को थोड़ा मिसलिनियस डे रहता है,
Friday
थोड़ा
तो each working day में
Hey, Friday is छुट्टी हो.
हाँ,
छुट्टी
रथ
रथ
यात्रा।
यात्रा है. Monday का दिन next week.
मंडे, ठीक है। फर्स्ट केस FA number 154 of 2025, counsel for the parties are present. They have filed their respective written submissions. The learned counsel for the respondents has in particular referred to para number
Internal page 54. I'm just running page 54. Just para number. It starts
Para number
from
7.
7.
It continues.
It continues. But page
at
50.
internal page 24 of the
Page
impugn
24 and 25.
judgment. 24 and 25 of the impugn judgment to submit that
To submit that the shares of the defendant was also sold by the plaintiff
to submit that both the parties
as sold shares of each other.
shares of
Both the
share
parties have
had sold the properties from the
Ah,
joint
ah,
family.
Yes, joint family corpus, hodgepodge, common hodgepodge.
Post on Monday.
Yes. Read it from page.
इसका सॉफ्ट कॉपी नहीं दिया हमको रिटन
नहीं पेन ड्राइव में दिए थे
नहीं है
मैं हम तो मेल
आप-
किए मेल
हम पेन ड्राइव में दिए थे
मेल नहीं करने का है
ठीक हम मेल क्लियर कर देंगे ठीक
पेन ड्राइव में
पेन ड्राइव दे कल दे देते
रिटन सबमिशंस को टैली करने का पूरा काम है सोच नहीं सकता अभी देखा था
ठीक
ना
हम मेल कर दिए थे मंडे
written submissions are very risky for the councils also and also for the judges.
No, because this point was missing on the last occasion when I was directed. Then I saw that this point was removed.
Check it.
Can
ये सारे बस Monday. तो 4 पेज में चलिए और
Orders item 7 second appeal 360 of 2016.
Yes. Why is it listed? बताइए आइए बोल
Substitution. Setting aside the written details.
respond number 1
Yes, yes.
setting aside abatement and all अभी नोटिस जाएगा कि नोटिस जा चुका है
जा चुका है रिप्लाई भी फाइल करके ऑनली विटनेस की जो डेट ऑफ डेथ एग्जैक्ट डेट ऑफ डेथ हमको नहीं पता लेकिन स्टेटेड पिटीशन ऑल्सो
नोटिस कब हुआ था आप हैं लीगल यूएस एंड रिस्पोंडेंट की तरफ
Yes,
से
actually,
एप्लीकेशन
we have annexed the death certificate.
कब है डेट
That है 21/2/2023
21
years.
23 to 2023 आपको
21 to 2023.
21 to 2023 फाइल कब किया आपने सब्स्टिट्यूशन कर देते हैं डिले क्या करना है इसमें हाँ? According to you, what is the date of death? April 20.
उनकी जैसा इनको पता चला वैसे ही
तो लेकिन बाद में डेथ हुआ है एक्चुअली में 23 में डेथ
might be back because
that might be correct and it is in your favor only आपने लीगल ईयर सक्सेसर्स का वकालतनामा फाइल किया है वकालतनामा कहाँ है क्या कौन कौन है
only one person survivors हर साल
कौन मंटू कुमार साहा
ये बात
देखिए सेकेंड अपील 360 और 2016 with IA number 13885 of 2024, IA number 17 of 2025, IA number 3514 of 2025. The learned counsel for the appellant has submitted that IA number 13885 of 2024 has been filed seeking substitution of respondent number 1 who as per the petition said to have expired in the year 2020. And IA number 17 of 2025 has been filed seeking condemnation of delay in filing the substitution petition, and IA number 3514 of 2025 has been filed for setting aside the abatement. The counsel for the legal year of respondent number 1 has submitted that the actual death of respondent number 1, date of death of respondent number 1 is 21/2/2023. The death certificate has been placed on record. He has no serious objection so far as substitution of respondent number 1 is concerned, he has already entered appearance by filing wakalat. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, the interlocutory application for substitution of legal heir of respondent number 1 along with petition seeking condonation of delay through IA number 17 of 2025 and also setting aside abatement through IA number 3514 of 2025 are hereby allowed. Counsel for the appellant is directed to delete the name of respondent number 1 from the cause title and insert the name of legal heir and successor of respondent. संतो बाला मंटू कुमार से। ठीक, बताइए अब क्या करना है? हो गया आपका सब्स्टिट्यूशन, एडमिटेड अपील है। 2016 से अभी तक एडमिट नहीं कराए हैं। कितना जनरेशन बदलवाना है? 2 वीक्स। हमको तो नहीं लगता है 2 हफ्ता बाद हम जिंदा रहेंगे, मरेंगे, कोई आइडिया नहीं है। थोड़ा तो आप लोग सोचिए। हाँ, 2016 से ऐसी पढ़ा क्या कर रहे हैं? कॉन्करेंट फाइंडिंग है कि रिवर्सल? पार्टीशन सूट है कि क्या है? टाइटल सूट है 2001 का। कितना साल हो गया? चाहिए 2 decades. Post this case under appropriate heading on next Monday. टाइम मत मांगिएगा, हम तय नहीं तैयार हो जाएंगे। हिंदू पेमेंट्स राइट टू प्रॉपर्टी पर, राइट 1956 अमेंडमेंट पर।
Item 8, second appeal 531 of 2017.
There is one IA for substitution of the legal years of November 21, 16, 80 or 76. And
now this would become a never-ending process here. But it has, your Lordship may see order dated 2/5/2024. They are the original plaintiff, their suit was dismissed, appeal dismissed, and they are claiming on the basis of, their whole claim is that the cadastral survey and revisional survey entries are wrong, based upon Abdul survey they are claiming. That means more than 150 years ago they say that they were originally recorded. And initially when they filed, it was barred by limitation of 53 days only. Now notices were issued and then therefore this order dated 2/5/2024 was passed. Because I had pointed out at that point itself before the Honorable Court that if there is no merit in the main appeal itself, then there is no question of consideration of appeal on limitation also.
Limitation has been dismissed.
No, in limitation notices have been issued. So therefore this order was passed on 2/5/2024, where it was taken note of the fact that although there is a
Under such
limitation.
circumstances, requirement of service of notice in limitation matters is dispensed with at this stage. अगर मान लीजिए आपका substantial question of law हम frame कर देते हैं, तो हम notice करते हैं.
And after that order, minutes, one coordinate bench has ordered to issue notices. on
But
limitation
without recalling that order, without.
नहीं ऐसा है ना, अगर मान लीजिए कोई substantial question of law हम लोग पाते हैं, तो हम लोग कर देंगे ऐसे. फिर आपका substitution वगैरह हम लोग consider करेंगे. अभी क्या consider करेंगे बताइए.
ठीक है, अभी एक डेट इसमें फिक्स कर दिया जाए अभी आप नोटिस.
एक बात बताइए मिस्टर गुप्ता, just respond. In case we hear the matter and we find that there is no substantial question and we dismiss, and if he has to go to Supreme Court, किसको पार्टी बनाएंगे? मुश्किल है ना.
मुश्किल तो है, but
बहुत मुश्किल है. वो पार्टी किसको बनाएंगे? And then he will have to annex these orders.
this actually everything cropped up because notices were issued. Therefore, this initial stage is
आप हमको ये बताइए कि इसमें
और इसमें हम जो है कि पेपर पब्लिकेशन का प्रोसेस कर देते हैं, उसके बाद
कर लेने दीजिए.
हाँ ठीक है, हम
आएंगे. ठीक है, नहीं तो
my only anxiety is that it would go on for decades
It
without
will not go
permission.
on.
Your
ये
Lordship,
आप मेरे पास नहीं चलेगा
हाँ, ठीक
ऐसा.
है, ठीक है,
बस
whatever.
पेपर पब्लिकेशन होगा
हाँ
और हम
ठीक है,
सुनेंगे.
ठीक है. Your
ये नहीं
Lordship
चलेगा.
may pass appropriate order, I'll not
यहाँ
say.
इंडेफिनेट नहीं चल सकता है. बताइए कब आप क्या करेंगे? कौन कौन सा आइए आप फाइल किए? अभी तो कुछ कुछ का सर्विस
1948 of 25 for substitution of the legal years of respondent number 21, 16, 18 and 76.
रिस्पॉन्ड नंबर 16, 21, 18 तो नहीं है सर.
80.
अच्छा ठीक है. 16, 21, 76 एंड 80 ये सब एक ही दिन बने हैं.
Different date.
Who died on सबका एक ही डेट लिख रहा है. उनके लीगल ईयर्स कौन है?
Legal years I have already mentioned. In 16 का legal years para 5 में.
अभी और भी लोग मर गए हैं. तो और भी लोग मर गए. क्या रिस्पॉन्ड नंबर 15, 16, 25, 26, 36, 39, 40 to 42, 44, 75, 76, 80 and 88 have died. क्या करें हम? बताइए क्या हम लोग कर सकते हैं इसमें?
हम सब्स्टिट्यूशन फाइल करेंगे या फिर
16(6) का ये नोटिंग है. ऐसे बहुत ज़्यादा दिक्कत है ना. कुछ लोग नॉट फाउंड हैं.
इसीलिए मैं चाहता हूँ पेपर पब्लिकेशन के
Therefore,
बाद
किसका
with regard
paper
to not
publication?
found, everything can be done by way of paper publication.
Yes.
With regard to not found, but
लेकिन
with regard
बाकी
to
जो
all the persons who
डेड
have
हो गए
died,
उनका क्या करेंगे?
हाँ, they have.
और एक चीज़ बता दे रहे हैं, अगर आप सब्स्टिट्यूशन विद इन टाइम नहीं फाइल करेंगे और एक बार अगर अबेट कर गया, ठीक है ना, देन अंडर सच सर्कमस्टांसेस आपका ट्रंकेटेड डिक्री तो पास नहीं होगा. यही ना इम्पैक्ट होगा इसका.
Impact it. But
इम्पैक्ट होगा, डायरेक्ट इम्पैक्ट होगा अगर
it
आप
seems
substitution
that they are
नहीं करेंगे.
claiming as representative capacity, so it can be heard on merit, and then on merit also it order can be.
Respondents are on representative
They
capacity.
also are claiming on the basis of
क्या केस फाइल किए?
नो नो
इतना रिप्रेजेंटेटिव कैपेसिटी
representative with regard to the defendants they are claiming.
हैंडल करना मुश्किल लग रहा है.
एक बार they had earlier also taken time for filing substitution.
no I have already filed.
तो इसका कोई उपाय बताइए. ऐसे नहीं कर सकते. देखिए IA number 1948 of 2025. This petition has been filed for substitution of deceased respondent number 16, 21, 76 and 80. The details of the legal heirs and successors have been mentioned
Para 4 to 7.
in paragraph 4 to 7 of the interlocutory application. Let notice be issued to the proposed legal heirs and successors of respondent number 16, 80 and 76 to
21.
the concerned police station for which requisite be filed by the appellant within a period of 1 week.
2 weeks below.
So far as 2 साल दे देते हैं
नहीं, only 2
नहीं
weeks.
2 साल काफी होंगे. So far as the respondent number 21 is concerned, the requisites be filed for service of notice upon them through speed post. Local वाला तो चला जाएगा पुलिस
He
स्टेशन.
has filed on behalf of 21 that he has filed.
21.
Yes, ma'am.
Oh,
On IA information he has filed.
अच्छा तो
Triple
आप
one.
वकालतनामा फाइल कर दीजिए.
Yes, ma'am. फाइल कर दिए.
Okay. Mr. नाम बताइए.
मनोज कुमार राव.
Mr. Manoj Kumar Ram has submitted that so far as legal heirs and successors of respondent number 21 are concerned, he has already entered appearance
Yes.
by filing wakalatnama.
One IA also has been filed for the information.
And their name has been brought on record by filing a petition under Order 22, Rule 3 and Rule 10, capital A of CPC.
Here there's one problem. I would not have pointed out. Because your Chief, he is not a party in the instant suit till he is actually substituted.
नहीं जब तक अभी नहीं कर रहे हैं substitution, notice नहीं कर रहे हैं.
Only yes.
Therefore, no notice
Yes.
need be issued to the legal heirs and successors of respondent number
Yes.
20.
And he must substitute.
और ये आप through police station कर दीजिए, ठीक है? और as per the office note, the respondent number 15, 16 तो हो गया already. Respondent number 15, 25, 26, 36, 39, 42, 42, 44, 75, 76, 80 and 88 have expired. Counsel for the appellant has also submitted that with regard to some of the respondents who are not traceable, he shall file appropriate petition for substituted service of notice through newspaper. अब अगला हफ्ता आपका थ्रू पुलिस स्टेशन जाएगा नोटिस और इस बीच आप सब्स्टिट्यूटेड वाला भी फाइल कर देंगे. बाकी लोगों का लीगल ईयर सक्सेसर पता कर लीजिए जो लोग मर गए हैं उनका आइए फाइल कर लीजिए. Post this case on July in the supplementary cause list. और कोई अर्जेंट है? कोई अर्जेंट है आपको बताइए?
आइटम नंबर 13 ये बहुत इम्पोर्टेंट है.
आइटम नंबर
13.
जिसका जिसका इम्पोर्टेंट है और जो लोग चाहते हैं उनका केस टेकअप हो जाए अपना करा लीजिए. लाइव कॉल करिए.
Item 13.
In this case, what the notices in limitation matter was issued. Why it is urgent? I am just pushing for the purpose of limitation. Just see, the 9th of May 2024 notices were directed to the issue to respond number 6 by both process. Then I took this step, these others, the notices have been served. So far the previous order is concerned, fine, except response number 6, which is going on since 2023.
नहीं आप ऑफिस रूट में ही देखेंगे सर, आप देख लीजिए ऑफिस। रिस्पॉन्ड नंबर 8 इस्लामपुर थाना के अंतर्गत सबलपुर गांव नहीं है, इसलिए नोटिस बिना तामीला वापस किया गया। रिस्पॉन्ड नंबर 7 नॉट फाउंड।
8. Response number 7 and 8 are none else but the own children of the response number 1 and of the same family. They are avoiding, because they are proceeding with the execution case. It is a judgment of reversal. So they are.
तो वहीं से सर्व करना लीजिए नोटिस थ्रू देयर काउंसिल।
इतना ही हम चाहते हैं। Council appearing as a decree holder.
एग्जीक्यूशन कोर्ट में बताइए कौन सा एग्जीक्यूटिव।
I have already filed an interlocutory application. The order sheet execution case 68 of 2022. 68 of 2020. IA number 11654. I mentioned the case number. First paragraph and prayer portion. Execution case number 68 of 2020.
SA number 119 of 2022. The learned counsel for the appellant has submitted that the respondents are avoiding to receive notice in the present case and they are proceeding in the execution case, being execution case number 68 of 2022, now pending in the Court of Learned Civil Judge within bracket Senior Division, bracket close Roman 6 Dhanbad, and a prayer for stay of execution has also been filed through IA number 11654 of 2023. The learned counsel submits that he may be permitted to serve notice to the respondents through their advocate who is conducting their case in the execution case. Considering the aforesaid submissions, counsel for the appellant is permitted to serve notice to the respondents who are not appearing in this case.
7 and 8.
Who are not appearing in this case, देख लीजिएगा. Through the advocate who is appearing in the execution case. The requisites for which we filed before this court within a period of 1 week. The affidavit of service.
The office will be directed to.
Yes. Office will provide the notices to be served through Dasti.
Yes.
To the advocate who is conducting the execution case on behalf of the respondents of the present case. The affidavit of service of notice will be filed before this court within a period of 3 weeks there. Affidavit, the notice be served in presence of witnesses. थोड़ा witness करा लेंगे. Post on 3rd August. आपका है?
Short prayer. Serial number 21, ladies. We have filed injunction. No, it is not time.
Injunction.
Injunction will not be.
No, we will not.
Your Lordship, it has not been admitted as yet. First appeal, Your Lordship may issue notices and.
Admit नहीं हुआ अभी तक. हाँ?
नहीं.
Notices were
Injunction में.
Actually, the respondents are there. Some
आप-
construction is going on there. That's why we have filed injunction.
इंजंक्शन पे नोटिस जा रहा है और अभी अपील एडमिट भी नहीं कराए.
This was the urgency.
फर्स्ट अपील में क्या करना है बोलिए. आप हैं?
Respondent number private has been 1 to
In the matter of limitation,
हाँ लिमिटेशन पे नोटिस गया था अभी
हाँ।
प्रीमेच्योर
प्रीमेच्योर तो है, कंस्ट्रक्शन आप करते जा रहे हैं
नहीं
तो
कंस्ट्रक्शन नहीं
premature
कर रहे फ्रिवोलस पिटीशन लॉर्डशिप
Frivolous?
हाँ फ्रिवोलस कोई कंस्ट्रक्शन नहीं कर रहा कोई बेचने स्पेसिफिक कुछ लिखे भी नहीं है पिटीशन में
Respond number 1 to 4 has appeared. Respond number 5 with report of process server that notice has been served through competent staff.
तो
service complete हो गया।
डिप्टी कमिश्नर
Service complete है।
नहीं ऐसे भी डिप्टी कमिश्नर है कैन बी रिप्रेजेंटेड
हाँ नहीं उसका कोई जरूरत नहीं। उसको कल रख देते
वही
हैं।
मेन कंटेस्टिंग पार्टी
कल आप आइए, कल सुबह सुनेंगे। इसका टाइम फिक्स कर।
नेक्स्ट वीक हमको 2 वीक टाइम दिया जाएगा
क्या चीज के लिए?
रिप्लाई देने
क्यों नहीं आप अभी तक रिप्लाई फाइल किए?
अभी तो जस्ट ये फाइल ही किया ऑर्डर 39
कैसे अभी फाइल किए? इसमें फाइल नोटिस पता है कब का है? बहुत पुराना नोटिस गया हुआ है आपको।
नोटिस गया हुआ पिटीशन फाइल किए हैं अभी
he is saying about injunction we are
छोड़िए ना इंजंक्शन का कहानी, पहले तो लिमिटेशन का नोट करेंगे तब ना।
तो भी नेक्स्ट वीक हमको फाइल अरेंज करना है अभी तो लिमिटेशन में नोटिस गया था
इनको सॉफ्ट कॉपी दीजिए तो। सॉफ्ट कॉपी क्या फाइल अरेंज करना पड़ेगा? ऐसे नहीं हो सकता। इतना दिन तक डिले कंडोनेशन का आपने रिप्लाई नहीं फाइल किया, कितना आपको फाइल करना है? रख देते ट्यूसडे को सप्लीमेंट्री लिस्ट में टू बी टेकन अप एट 1 o'clock।
नेक्स्ट
हाँ फाइल कर देंगे तो ठीक है, नहीं तो फिर डिले हम कंट्रोल करेंगे। लिखिए FA नंबर 198 of 2024. Notice was issued in the limitation matter as per the office note. Considering the office note, the notice is accepted as validly served. Post this case on Tuesday in the supplementary cause list to be taken up at 1 o'clock.
नेक्स्ट
For the purposes of condonation of delay.